Senators Luchtmeyer.
Here.
Schroer. Coleman.
Here.
May.
Here.
Roberts.
Here.
Thompson Raider. Trent.
Here.
Got a quorum.
We do have a quorum. I now make a motion that we go into executive session. Do you have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. We are in executive session. Now make a motion to bring before the committee Senate Committee Substitute for House Committee Substitute for House Bill 196 et al. Do you have a second? Second. It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. The committee, the bill is before the committee. We do have a Senate Committee Substitute. It's been previously distributed to the members of the committee. What it does is it removes a couple of provisions, one relating to intervention fees. This looks like something that had not been vetted or heard in the House and kind of got thrown on the floor. And so we kind of were looking for some things that maybe have not been through the full deliberative process to remove some of those. We removed the compensation for wrongful convictions, and didn't we replace that with the Senate version of it because it didn't fit? Okay. Okay. The provisions relating to credit for jail time, part of that is because of an agreement that the Senator Roberts and I have on a related and unrelated piece of legislation that would not fit on here, and so I want to make sure those two provisions, Max's law and that, stay on bills together. And we would have to expand the title to public safety, which I'm kind of reticent to do. So that's why that provision was removed, not because of any hostility towards that provision. It will be, by the way, in several omnibus judiciary bills that are coming to the floor. And then it adds a provision relating to unsupervised jail visitors. The title will remain offenders in custody, and this will be kind of an attempt if we need to pivot to a more narrowly titled bill that deals with some corrections related issues. This will be kind of the vehicle to do that. So with that, be happy to answer any questions or entertain any discussion on the substitute before we make the motion to adopt it.
So is this with the House Committee Substitute added in of 119?
Senator May, that is correct. So yeah, right, but not Senate Bill 119, just to clarify, because I know you and I have worked on a Senate Bill 119 that's over the House. This is the House Bill 119 that we heard last time.
Yeah. And so this bill still has the, so tell me about that section where, the violations report, violations report to the prosecuting attorney or circuit attorney, ask the court to add a condition or sanction to a term of supervision. So that's saying that if I'm already out of prison.
Can you direct me to the section that you're talking about?
Let's see, just some of the sections on there, but here are.
Are you talking about the earned discharge credit? Are you? So we've got. I'll kind of walk through the provisions that we've got in here. We've got the supervision of adult offenders from other states. That's the Interstate Compact. I believe that was Senator Gannon's bill.
Okay, go ahead, I'll ask you about that later.
Okay, earned discharge. We've got the capping the amount of fees for inmate phone calls so that it can't be over a certain amount. A provision relating to visitors to correctional centers. This is to address a specific situation involving somebody, I guess, who's been to some of the DOC facilities and has been disruptive. And then information from parole officers, and then electronic notifications. This is the provision that we've heard in the committee separately that has to do with being able to notify victims via email. Right now it has to be via certified mail, and so this gives the option to do that notification electronically as well. And then the final thing in there is the drug treatment program repeal. This is a cleanup provision. I believe Senator Trent had it over here. But that's it. That's the entirety of the substitute.
Okay, so, for 589.564.
Okay, 589. Okay.
Page 12, top 4.
So this is all, I think this is all interstate compact language. And again, we passed this identical bill out of the committee from Senator Gannon. I believe it was unanimously passed out of the committee. Is that correct?
Was I there?
Well, we will find out. The Senate research is checking that out for us right now, Senator.
Mr. Chairman, to inquire,
Senator Coleman.
did the section on limiting visitors as such visitors, this is including access of judicial visitors, your attorney?
This is specifically, without getting
Has that
into
had a hearing, that 776?
that provision, I don't think it has had a hearing.
And
I
that's the
think it
only
can.
place that it was filed?
Say it one more time.
That's the only place that it looks like it was filed, was in House Bill 776, and it looks like that hasn't, I don't think it's had a hearing even in the House.
Correct. This is to deal with I think a fairly specific situation involving a member of the General
So
Assembly.
bad facts make bad laws. So I have some concerns about limiting access of attorneys to their clients and would like to see that, make a motion to strike that section.
Does the provision eliminate the ability of attorneys, or does
Yes.
it deal with General Assembly?
It does, includes attorneys, is my reading. I'm happy to take a closer look at that together, but it looks like we're limiting attorneys visiting their clients.
Senator, can you clarify which section
I'm sorry,
you're talking
yes,
about?
it's not actually cited at all. It's section 217-265, and it doesn't actually have, looks like it wasn't filed as an individual standalone bill.
Okay, can you give me page and line number?
I don't have that information. I'm working for the summary and haven't had a chance to closely review the sub after our activities over the evening last night.
Okay.
All of us on the floor, I should be very specific, excuse me.
Page 5.
You've got it on page 5?
Yeah, 217.
265. What page is that on, 5?
Yeah, page 5. So it's, so the provision,
Following
provision.
provisions shall be
Yeah,
authorized to
so,
visit the
so,
correctional
so
center.
so the language that's being added to it under section 2 is that you've got individuals who are entitled to visit correctional facilities, which includes members of the General Assembly, judges, et cetera. And it says, we're adding subject to rules that may be deemed necessary for maintaining security and safety.
Yeah, I feel really uncomfortable with this unvetted language that hasn't been looked at over here, wasn't even filed as a standalone bill, and I'd like to see it, make a motion to remove it.
Well,
Senator
I
May.
think that, let me get where you are first. You're on,
So we're on page 5.
of the substitute? Okay.
I agree, which is why I have made a motion for the body to remove that section.
Senator May, did you?
Yeah, I think that this was because, they had some issues and they had no authority to act,
Yeah, that's
at the
my.
correction center. And does it put attorneys in there?
Well, it puts in prosecuting attorneys. So this provision deals with public officials' access. So it deals with, you can read them all here. It's department employees, governor, lieutenant governor, General Assembly members, judges of the Courts of Appeal, Supreme Court, Circuit Courts, Attorney General, State Auditor, State Treasurer, Secretary of State, Director of Public Safety, Adjutant General, Commissioners of Elementary and Secondary Education, Circuit Court and prosecuting, or Circuit and prosecuting attorneys. So basically, as I understand it, and the department's here, and Adam, we may have you come up to talk about the specific situation that we're dealing with, but we as elected officials have the right to go tour and inspect correctional facilities. There is no provision that says if somebody is doing something unruly or creating a situation that would make it unsafe in the prison environment, the department does not feel that it has the authority under current law to remove these categories of individuals from the facility if that type of conduct were to occur. And again, it's not dealing with attorneys for the accused or somebody who's incarcerated within the facility. It's dealing with public officials and their ability to access. And we're not saying you can't access the facility. We're just saying if you do something in the facility that creates an unsafe environment, that there has to be some ability of the department to remove that individual. Adam, why don't you come up, actually? Go ahead and fill out a witness form. All right, so could you just kind of briefly walk through the committee? I know you, myself, and the director, had a conversation about this. This is, as Senator Coleman pointed out, the bill has not been heard over in the House. We're at a point in the session right now where some of that vetting may be done for the first time in committee on a committee substitute, which is really what we're doing here today. I think that would be a benefit for you to kind of talk about the situation so the committee understands where this language is coming from, but we're really dealing with a very narrow set of individuals and circumstances as based on what is in the bill.
Yeah, Adam Allback, Legislative Liaison, Department of Corrections. As you indicated, under this law, it allows certain public officials access to the facilities at any time. The department does not disagree with the concept of allowing public officials access at any time. We have had some situations over the last few years in where we have been put in close to compromised positions with the security of our institutions. This is something that kind of came up not long ago in which we drafted this language. We attempted to come by, the director and I, to speak with members, but several were unavailable. But it will not, to Senator Coleman's point, it will not eliminate access to attorneys. We'll still have attorney visits just like we do now. Just the regular defense attorney or something, they don't have access to the facility at any time currently. It's just that subsection 2.
Yeah, and if you look at this statute, what it's really, I think, designed to do is to give some type of public oversight function where certain elected officials can go into the facility, maybe see it for educational purposes, maybe see it because we hear something at committee that's disturbing and we want to check out the facility. We're saying, yes, elected officials, you can absolutely still do those things, but if you come in and you create a dangerous environment for other inmates and for correction staff, there has to be some ability to remove that individual from the premises. And right now, you don't believe you have the authority to do that.
That's absolutely correct.
Is there any further discussion on this provision?
And so let me say this. So we're looking at section, only this is in page 6, section 4.
Starts on 5, yeah.
Okay, let me see the part on 5. And so this line, you said subject to such rules as may be deemed necessary for maintaining security and safety in the correctional center. So are you going to promulgate rules? You get what I'm saying? Subject to such rules as may deem necessary for maintaining security and safety. So are those rules already established, or are we talking about we're going to promulgate rules? What I'm concerned is when we're doing legislation, the vagueness. So say for instance, if it just comes up every time that, or you're talking about when we're on the premises, or if we're coming to the premises and it's a security issue, do we, at that time?
So I took the language that is now proposed to be in subsection 2, I believe, came out of, I think it's subsection 3 that pertains to clergy in that section. Simply what that is basically meaning is the department, we have generalized rules that we do for visitors to the institutions, which is like we will escort them at all times and those sort of things. That is what we were referring to. We're not referring to promulgating rules in regards to this.
Okay, very good. What is that?
I have a quick question for you. So, and there's a motion that's before the body after we're finished hearing your testimony.
All senators come to the chamber for session.
My plain reading of 217-2652 as drafted in that bracket at the end of the first sentence just gives complete authority, subject to such rules as may deem necessary for maintaining security and safety in the correctional facility. Is it your intention that you will eliminate all unannounced visits of the General Assembly to inspect public facilities?
Absolutely not. That is
Then
not.
then let's just get rid of that sentence and include only the second section at part 4, and then create an appeal process by which the General Assembly could override that vote. Or that decision-making process. I think that there's a large distrust among some populations of the state with DOC currently, and unannounced visits are one of the ways that the General Assembly is able to best represent the interests of their constituents and ensure that incarcerated members of our constituency are also represented. And so I feel deeply concerned about unvetted language. And if we're hearing it and vetting it for the first time right now in a committee hearing, when we haven't announced that we're vetting it, so we don't have an opportunity to have those who are opposed to the idea testify, us moving forward with it, because then it becomes something that this committee has voted on and in support of.
So here's what we're going to do. We're going to roll call this. We're going to vote up or down on the amendment to remove the entire provision, and then we'll see where the committee lands on it. Brad, please call the roll.
Senators Luetkemeyer,
No.
Schroer, Coleman, May, Roberts,
Pass.
Thompson Raider, Trent, Schroer,
So is the aye in favor of removal? Aye means removal, and the no means we're keeping it.
May,
No.
Roberts, Thompson Raider,
Aye.
4-3.
Your vote of 4-3, the amendment passes.
Motion to adopt the new Senate substitute.
Make a motion to adopt the Senate committee.
Sorry, can I make a comment real quick on that?
Sure.
Would we still be able to, in a sense, put that in the sub if we were able to tweak the language in a way that everyone was okay with? I've had conversations with the department. I think they've been working in good faith, trying to solve this problem.
Hang on just a second. We got to have people talk one at a time. So what I think would be the best process is to have some version of the language come out of the committee. What I would not like to do is send new language to the floor for the first time without any committee vote on it, because of course I can add a substitute on the floor that would put this or some substantially similar language in there. My preference would be is that some form of the language come out of the committee. If we want to keep working on the language, that's fine. Given where we are in session right now, that would need to be done offline through a floor substitute. But again, I don't imagine this language going back into a floor sub if the committee's vote to strip it out stands, because then the language will never come out of committee. So as the vote stands right now, my intention would not be to add this back into the floor substitute.
Got it. All right, and I guess if we were to add it, and if members had a lot of reservations, we could always just not put it in the sub when we get to the floor.
Right. If the amendment were to pass, what I would do is then visit with the members of the committee who have voiced concern, and either we would find a path forward with agreed upon language with the department, have it debated on the full floor, and if we didn't have agreement, obviously members could stand
Pull
up
it.
and have it be pulled out of the substitute.
Okay, so I guess we could do a motion to reconsider.
If you'd like
To
to make,
keep it in.
if you'd like to make the motion, because you were on the prevailing side, so you'd have to make the motion.
So the aye vote was to strip it out. No vote to keep it in.
Yeah. I'm just going to say I'm not going to do the motion to reconsider, but I would be open if we have the opportunity perhaps to amend this on the floor. I mean, I think that this comes from a good place and would like to work with all the committees.
Okay. I would
on
make a
this.
motion that we adopt the Senate committee substitute as amended. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. You've adopted the substitute. Now make a motion that we do pass Senate committee substitute for House committee substitute for House Bill 196 et al. Do we have a second? It's been moved and seconded. Brad, please call the roll.
Can we have a discussion real quick?
Oh, sure.
Yeah, just very briefly to make a statement. There's a lot of stuff I like in this bill. I'm going to vote no in committee, but I think with a few minor tweaks, I hope to be a yes on the floor. Thank you.
Senators Luchtenmeyer,
Aye.
Shore, Coleman, May,
No.
Roberts,
No.
Thompson Raider, Trent, Coleman. 4-3.
For your vote of 4-3, you have voted do pass Senate committee substitute for House committee substitute for House Bill 196 et al. No further business coming before the committee. I make a motion we adjourn. It's moved and seconded. We are adjourned.